asked that we not use the definition that had blood alcohol content. So I put it in, and that's the same definition that we voted for in 2011. It's also the same definition, I believe, that we have in the statute for closed carry. So that's how we define intoxicated in the code. With, you know, if you're publicly intoxicated, that's an offense already, but it's not as serious an offense. It's a class 4 misdemeanor to have that behavior already. But this would make it class 1 too with an open carry firearm. So if you maintain that by smiling or having a few sips of wine, that this would make you a criminal, you'd already be a criminal.
All right, any other questions? Mr. Chair, if you want the statutes to equally fill, it would be okay to remove the alcohol provision from the concealed carry program.
No, that's a different bill. That would be your bill, or a different bill. You're saying
you're concerned that they're not the same. So if we took the alcohol from the concealed carry, would that make it the same?
Well, of course it would make them the same, but that's
take care of your concerns.
not at all, Senator. The General Assembly decided to make that policy decision to have it in, and I think public. I would rather go the way South Carolina, Missouri, Texas, Tennessee, Oklahoma, and Georgia and Florida go.
Anything else?
Mr. Chairman, the answer, I think, to Senator Stewart's concerns would be on line 19 to remove the words intoxicated as defined in section 4.1-100, or remove those words. So what's left is a person who is under the influence of, and then insert alcohol or illegal drugs. If you do that, then that language is identical to the concealed handgun prohibition, and it also uses the same language as 18.2-266, driving under the influence. There is a crime to drive under the influence, you're under the influence of alcohol.
Mr. Chairman, but you're not taking away the de minimis standard that I'm concerned about. And there is a difference, I would say, in the drunk driving statute in this particular instance, because you could conceivably not be drunk, but your ability to handle a motor vehicle, which is a 5 tons bullet traveling down the road and very dangerous, where you may be fine physically and mentally after having had a little bit to drink and have possession of a firearm. What I believe the senator's trying to get at is people who are outwardly obnoxious, drunk, and shouldn't have a firearm. And I truly think that officers can already charge that under reckless handling of a firearm if they wanted to.
Actually, under reckless handling, there's a much higher burden of proof. You wouldn't be a violation until it was too late. I would say if you're concerned about 4.1-100, the rest of the bill says that there's other evidence if there's manslaughter, maiming, public intoxication, violation of 18.2-388, etc. But I guess the policy decision, if you want to work with me, Senator Stewart, and carry it by, if you have an interest in making the bill so that people who are seriously intoxicated can't carry it, I'd be happy to take it by and work with you.
I'm sorry, I shouldn't have been like that. The senator's asked for telling jokes while I'm trying to listen. I can't, because he's really funny.
Sometimes, occasionally.
You're trying to take away, fun.
No, let's just start.
He's more fun when he's drinking, but I wouldn't give him a gun.
You said something that you should go check it out.
Mr. Chair,
All right, Senator Deeds.
I'd like to ask Steve a question. Would you have to make, is that consistent with the amendment you will make, would you have to make the same amendment down on line 22?
Yes.
Okay, well then, I want to move the amendments that Mr. Benjamin suggested.
All right, report that, please.
On line 19, strike the words intoxicated intoxicated as defined in section 4.1-100 strike that language. On the same line, after influence of, insert the words alcohol or, and then on line 22, strike the quote marks intoxicated as defined in section 4.1-100 or. And then I think you either strike or don't strike the quotation marks. I haven't figured that out, but that's what you do.
Yeah, I'm thinking it out.
No, okay, you do keep it there because it's a definitional section, so you keep the quote marks, but you take out as defined in 4.1-100 or take that out.
Then before, after, under the influence of alcohol or drugs, make it consistent with the amendment.
Yes.
Everybody clear on that? That motion to amend is before us, properly seconded. All in favor, signify by saying aye. Aye. All opposed?
And I should note, alcohol was also added to that line 22.
Got it.
Yes.
That was in comments. All right, anybody wish to speak in favor of the bill? Yes, sir.
Mr. Chairman, Andrew Ballard, Virginia Center for Public Safety. We believe that public safety is influenced by the combination of alcohol and the presence of a gun, not the combination of alcohol and where the gun is being carried. If it's open or it's concealed, it's still that combination. And the National Rifle Association themselves say that you shouldn't drink and carry a gun.
Thank you. Yes, sir.
Josh Horowitz, Education on gun violence. We support this bill. We want to make clear the public health data makes it very clear that alcohol is one of the biggest risk factors for violence.
Thank you very much. Yes, sir. Yes, ma'am.
Good afternoon, Lori House of Educational Fund to Stop Gun Violence, and I'd just like to point out that gun deaths are on the rise and actually outpace motor vehicle deaths in Virginia for the last several years. And, you know, to speak to Senator Stewart's concern, we shouldn't be operating motor vehicles or handling a firearm when under the influence. Thank you.
Thank you. Yes, ma'am.
I just want to quickly point out the ties on behalf of the General Federation of Women Men's Clubs as far as alcohol abuse, inebriation, and domestic violence, and keeping guns out of their hands would help save women's lives. Thank you.
Steve Bachman, Fairfax Station, and as community member, as a mom, and for the reasons stated, I'd like to stay my opposition as well.
Thank you very much. Thank you. Anybody wish to speak in opposition?
Philip Bancroft, President of BCDL. Intoxication, I believe, is covered by the law generally, and we think that would be sufficient. And again, it's always gun owners being targeted for extra special treatment, and we just think the current laws are covered. Thank you.
Yes, sir.
Sam Hutchins again, just in opposition to it, and to clarify the carrying a handgun, no matter what you're doing, is not a danger to anybody. If you're drunk, if you're sober, if you draw the handgun, do anything dangerous to anybody else, there's plenty of laws about that. If you're drunk and you're carrying it and not threatening anybody with it, then there is no crime, there's no difference. Being drunk out in public, you got your own problems, there's rules about that. But just because you're carrying, the gun has absolutely nothing to do with what's going on. If you're concealed carrying, I hate differentiating between open and concealed carrying, but if you're concealed carrying and you're being belligerent jerk, there are laws prohibiting that. I would say more to prohibit people around you so that nobody picks a fight with you if you're open carrying, because you're belligerent jerk and you're carrying a gun. If you're concealed carrying and you're being a belligerent jerk, there are laws specifically prohibiting that, just to prevent the dynamic that somebody's going to pick a fight with somebody and they don't realize that they're drunk and carrying.
Thank you very much, sir. Appreciate it. Bill's before us. Chairman Barry Stewart.
again, I appreciate council trying to help us, but here's my concern. So I decide that, I'm gonna go out to hunt for the day. And I did. And we finished hunting and we had a nice day and we come home, so we stop somewhere and we have a meal. And you have a glass of wine or beer with your meal or two. And you got your shotgun in the back of the car. You get stopped for speeding and they smell alcohol on your breath. You're now subject to being prosecuted for this simply because you had a beer. Trust me, Senator, I know what I'm talking about. I do some of this practice, and my law practice. And because of that, what you're trying to get at, you're not getting at, and you are inflicting a lot of unnecessary, it could be hardship on innocent people who are not doing anything wrong, but happen to have a gun in their car. So with that, I'm going to go with you.
Motion to pass the bill by indefinitely. Is there a second? It's been properly seconded.
Mr. Chairman, could I just have a final?
I think we've had the final word on it. I think this is well developed. Senator Edwards,
Just want to
comment on the motion?
well, comment on the fact that it's got to be a loaded firearm worn by a person in a public place.
Thank you. Motion is to pass the bill by indefinitely. All in favor, signify by saying aye. Aye. All opposed? No. Motion is. All right. Have another bill or is that?
Yes, sir.
1266.
Yes, this would prohibit the use or handling of firearms by children who are 4 years old or younger. Right now, it's you're allowed to shoot a weapon with an adult present, or if you're under 12. But if the adult is not present, you're not allowed to authorize the child to use the firearm. So what this bill does is it says that it's illegal, if it's illegal for a person with the mental capabilities of a 4-year-old to handle a gun, why would he hand the gun to an actual 4-year-old? And in 3 to 4, children are beginning to name colors, remember parts of stories, and understand the concepts of same versus different. But I don't think it's expectable to ask them to grasp the concept of mortality loss or the danger of a weapon. And also, children that young are physically unable to handle the recoil of a gun. The adult, when they let the child handle the gun, is no longer in control of the situation. So if you require adult supervision simply or even with careful instruction, we cannot guarantee the safety of the child or anyone nearby if you're under 4. It's already illegal to leave out a loaded firearm to endanger a child under 14. I would argue that to leave a firearm in the hands of a child under 5 is doing just that. And, you know, we've had 2,100 kids hospitalized because of unintended gunshot wounds every year. And I just want to point out that this is a Virginia problem. 2016, just 3 cases I know of. Campbell County, a 3-year-old shot himself in the stomach while his dad stepped out to empty trash. In Norfolk, in July, 4-year-old shot himself while playing with another child. 2 adults were home. In Suffolk, in February, a 3-year-old shot himself when he found his mother's handgun. And I could go on in Lunenburg, Hampton, Hopewell, and over in Chesterfield.
With respect to those incidents, did any of those parents knowingly, or were they accidents in which a child came upon the handgun or the gun?
Well, they were home, but
Because your bill deals with knowingly.
right. Well, the point is, it happens. We know 2,100 kids, and actually, I had a gentleman in my office the other day from BCBL who told me that he lets his child under 5 handle his gun. And we've seen on the internet videos of a couple in Missouri who encouraged the child to put the gun in its mouth from 2 years ago. Now, hopefully the gun wasn't loaded. I'm sure they didn't intend for it to be loaded.
Do you
But
think that there's a crime that those folks can be charged with?
no, I spoke to my Commonwealth's attorney. Under reckless handling, he feels the adult gun owner would have to be the person recklessly handling, not trying to avoid the dangerous situation with child handling. So that section doesn't seem to apply. I think that
How about contributing to delinquency for minors?
I think this parent said it was fine for him to do it, and BCDL thought it was okay under current Virginia law.
Well, counsel, do you think, let me ask our lawyer, do you think that this conduct would be covered under contributing to delinquency for minors?
I think that it could, Mr. Chairman. The crime you allude to exists if a parent of any child willfully does anything to cause a child to be abused or neglected, as defined in another section. That other section says that an abused or neglected child is someone, is a child whose parents have created a substantial risk of death, disfigurement, or impairment of bodily or mental functions. I think that statute is broad enough to cover the conduct embraced by this bill.
All right, anything else?
Yes, sir.
And this is, I would point out to the members committee and patronage, this was introduced in 2016. I've heard before this committee was saying the same people in the audience.
Right. I'll keep bringing it back. We don't pass it today, but I want to. I'll be brief. When parents, I respect parental rights, but we can't allow them to materially endanger a child. We have specific laws against parents smoking in a car with a 4-year-old. Specific laws, you can't serve alcohol to a 4-year-old. You can't allow 4-year-olds to place their tiny hands on the wheel and drive. Why should they be putting their tiny fingers on a trigger being any different? I think that our founding fathers weren't talking about toddlers when they drafted the Second Amendment. And I think it's important enough to be explicit that you can't let the child handle a gun. But under the code, I would disagree with Mr. Benjamin in that you are allowed to have, to knowingly authorize a child to use the gun when the parent is present. And I don't think you should let the 4-year-old use the gun even if the parent's present. We heard about the kid with the machine gun who shot his instructor a few years ago. So I would just say that 4 and under is a bad idea.
I don't think a single person up here disagrees with your fundamental proposition. I think the larger question is whether this is covered or not. And, more tonight than not last night, I think we all understand the parameters of the debate. So.
I just found it disturbing that the BCDL representative in the office said that he lets his child, his 4-year-old, handle a gun, and if it's covered.
We're here to talk about policy, not about individual action.
Okay, well, not about, it's not widely known that this is a crime, apparently, if the experts don't know that.
Thank you. In favor of the bill.
Mr. Chairman, Andrew Garrard, Virginia Center for Public Safety. More Americans are killed each year by children under 4 with guns than we lose through gun violence by international terrorists on our soil. We're seriously worried about international terrorists. Why aren't we equally worried about what happens with 4-year-olds?
Mr. Chair,
That's what.
you're aware this is already illegal.
It's already illegal.
Yes, sir. Are you aware of that?
No, I'm not aware of that.
Thank you. Yes, ma'am.
Yes, Mr. Chairman and committee members, Carol Nagel with the League of Women Voters, and we have a great concern about protecting children from injuring children. And so we appreciate this concept, and maybe a deterrent such as a penalty does not really have any effect, but the concept is what we do support.
We get a lot of agreement here. Thank you.
I just want to remind the committee that I'm representing 4,000 women in Virginia that have active clubs that very much care about this issue, especially when it comes to children. I understand that and when an incident happens, that the law does create a way for there to be prosecution. However, as a parent educator who used to work for CHIP, there's something to be said about passing this bill and sending out a message to the public that's clear, that it's unacceptable for children 4 and under to have a bill. And we rely on you, we trust you with the public safety, with parents who really honestly don't know any better until you spell it out specifically. And through this, when they say what bills were passed in the General Assembly, you will be saving lives. Please save our children's lives today.
Hi, I'm Lynn Harris. I'm the grandmother of a 4-year-old, and I think that specifically calling out that a child should not have access to a firearm is a wise thing to do. Thank you.
Thank you.
Good afternoon, Lori House, I support the bill.
Thank you. All right, let's hear from opponents.
Sam Hutchins again. Very disappointed with how people consistently fail to draw a line between an innocent activity and one that has a bad outcome. All gun activities that have bad outcomes are all illegal and they have punishments attached to them. Good activities that have no bad outcome should have no penalties to them. There are plenty of people, more than the one VCDL representative that he spoke to, who allow their children to fire firearms, 4 years or less. They make them, the 22 rifles, they make them in pink, single shot. You know, you set it up on a bench and the kid can shoot with the parent. Lots of laws. If nothing bad happens, then nothing bad happens.
Senator, I might ask you a question. Well, I just stopped Senator Stewart from asking witnesses questions. Let's listen to the witnesses and move on.
Somebody want to start something?
Well, I was just curious whether you thought that the only thing to stop a bad toddler with a gun is a good toddler with a gun.
No, sir. That's a good parenting. But prohibiting from the legislator that a good toddler with a gun can shoot, that's bad legislation.
All right, Senator Evans, let's wrap it up.
Not much to say, except that I hope that there are no more guns, that we don't have to come back here next year and hear about more Virginia gun tragedies. I think that we need to send that clear message. If we can be explicit not to smoke in the car, we should be explicit not to let the child handle a gun when we know what's going on.
Senator Stewart.
Mr. Chairman, I understand what the Senator is trying to do. My only concern is this. I did spend a little bit of time as a Commonwealth's attorney. Somewhere in the back of my mind, I thought that this could actually be a felony under some circumstances based upon the outcomes. The bill does not distinguish between a loaded firearm or an unloaded firearm. And there are other questions I have about it. But I would ask you, can you absolutely research this? Because I believe you may be lowering the penalty in some cases, making it less of a crime.
I spoke with my Commonwealth's attorney, and I brought a letter from him last year. I have not looked at that letter this year, but he thought this would be a useful tool. I don't intend to lower the penalty. If you want to vote for the bill, we could ask Mr. Benjamin if it lowers the penalty, but otherwise I don't know what the point is.
The bill is before us. So I'll move to.
Substitute Mr. Motion, Mr. Chairman,
The substitute motion is to pass the bill by indefinitely. All in favor, signify by saying aye. Aye. All opposed?
No.
Thank you, Mr. Chairman.
All right, next we have verification of Senator Chase. Next 1422.
Thank you, Mr. Chairman, fellow colleagues. I have before you Senate Bill 1422 and Senate Bill 791. They're actually very similar. Last year, I put forth Senate Bill 791, and you all have heard that, so I'm not going to
go into that. It was basically fees for processing. It had to do with a clerk having the option to waive that fee. There was no fiscal impact. It went to Senate Finance, came back out, actually passed over to the House, where I worked with Delegate Lingenfelter and that committee to come up with the bill that I'm going to present to you today, which is Senate Bill 1422, and hopes that it also passes the House this time.
We've got 1422 that eliminates, leaves the fee at $10, which would be allowing under 791 the clerk to waive the
So this is a good compromise bill that I hope will.
Well, let's take it one step at a time. We start with the 1422, which would lower the fee from, my understanding is $35 to $10.
Yeah, well, what we're going to do is I'm going to offer a substitute amendment, which I believe we submitted this morning, and you all will have before you to eliminate that fee, removing the $10 and the $35 clerk's fees. The $5 state police fee remains. We appreciate the permitting is currently done by the state police and done very well, I might add.
Let's first adopt the committee substitute. Senator Stewart moves, Senator Norman seconds the adoption of the committee substitute. All in favor, signify by saying aye. All opposed, committee substitute supports. Tell us what the bill does now.
Okay, great. What Senate Bill 1422 does, as it pertains to, it has to do with fees. Anytime you get a concealed handgun permit, the maximum it used to could be that you would charge would be $50, which includes a $35 local law enforcement fee, $5 state police fee when they do the background check, and then a $10 clerk fee. What we're doing is we're looking to eliminate the fee under the current law up to $35 that a local law enforcement agency is permitted to charge for conducting the background investigation for concealed handgun permit. 2, the requirement that the local law enforcement agency forward to the state police any amount assessed by the FBI for providing criminal history record information and the background information. And then with the amendment the substitute just did, it used to be the bill makes discretionary the current mandatory fee of up to $10 charged by the clerk for processing a concealed handgun permit application of issuing a permit. The bill increases from $10 to $20 the maximum amount designated solely to fund courthouse and courthouse security that a local governing body may assess against a convicted defendant as a part of the cost in a criminal or traffic case in district or circuit court. The sheriffs are in support of this bill. And I have other folks in the room who are in support of this. Prince William County, I believe, is here. Speak in favor of the bill. Is there anyone, I mean, that's basically, and I believe the NRA is staying neutral on this bill.
So, all right. I couldn't find the $20. I found it.
Okay, great.
Yeah, so you provide for the state police fee that remains at line 19 on here.
Right.
And then on line 70, you provide for $20 fee to be assessed by the city of Calhoun. All right?
That's correct.
Okay. Any questions?
Mr. Chairman,
Senator McDougall.
just want to make sure I understand this logistically. So now, under the current law, somebody goes to get a concealed weapons permit, that individual pays the fee. Under your proposal, that individual could pay no more than $5. And then anybody who gets a traffic ticket for doing 5 or 8 miles over the speed limit, or somebody who's charged with having their inspection sticker not done in a timely manner, or their DMV doesn't send them their details in a timely manner, now they're going to get a $20 penalty when they get a court.
Right, they would bear the burden of that. instead of the taxpayer.
Mr. Chairman, I guess I will quibble with all of those individuals, who, some of them are in this audience who are probably taxpayers, who might have had their decals a week late and get a penalty that are going to be paid at this point.
Let me ask you this. I know you're not on the courts committee, you've kind of heard some of the bills dealing with community service. But I suppose I'd ask council, I would maybe ask council whether, considering the Supreme Court's recent rule or the legislation that's been working through the General Assembly, whether this is a fine that is actually going to be collected, or whether community service can be worked to work this off as well. And that's fine, that's fine. This may want to, if it passes out of this committee, it has to go to finance anyway, and they give us an opportunity to further examine that issue.
And if it helps, it's already in appropriations in the House, the same bill.
Well, we're worried, I understand you're trying to provide that $20 somewhere.
Right.
But the issue is, there's a recent rule from the Supreme Court and legislation that says that $20 may not actually ever be paid. All right, any other questions? All right. Sir, Pete.
Have you considered whether or not this is an unfunded mandate for the clerk's office or local police to have local coach investigation?
Yes, that has been taken into account. It, this particular, actually my bill that's coming up next has no fiscal impact. This particular bill has not been to finance yet, so we don't know what the fiscal impact statement would be if there is one. Fair enough. There's not one on it as it is right now.
Mr. Chairman,
Sir, Pete.
I'm trying to understand this.
I understand.
Are you taking the fee away from the person who's applying for the concealed carry permit and then transferring the cost of that to anybody who commits a traffic offense? Is that right? Is that how this reads?
Yes.
Okay, that's how it reads.
All right, any other questions? All right, speakers in favor of this? Speakers in opposition? Yes, sir.
Mr. Chairman, Andrew Gallagher, Virginia Centre for Public Safety. When a person applies for a concealed handgun permit, the clerk of the court has to do some work. That work has to be paid, and the work is being done on behalf of the permit applicant, not on behalf of the general public. We believe that the permit applicant, when he requires work to be done on his behalf, should not ask taxpayers to pay for that. Speaking as a taxpayer, I have no problem with actually paying more taxes to get courthouse security improved. But having to pay for something which you want for yourself is not something that should come out of my taxes. Maybe I should get a bill to get sex offenders to pay for my fishing license.
Good afternoon, Lori Haas with the Educational Fund to Stop Gun Violence. We oppose the bill. I can't quite wrap my brain around the fact that someone is applying for a permit or a license of whatever sort, and that the fees and the fee structure to cover the work that is necessary to issue that permit or that license is covered by another person, whether that person's a criminal or a traffic offender or not. There are many licenses and permits that the Commonwealth issues. I suggest my husband, who's a contractor, pay for his license. I would speculate that several of you lawyers on this pay for your license. I suspect that motor vehicle operator of, a commercial vehicle has to get a special permit. This is something that the Commonwealth has deemed is process-oriented. It has a process, the process exists, and somebody has to pay for that process. And I would speculate that it should be the applicant. So for those reasons, we're opposed to the bill. Thank you.
Yes, ma'am. Yes, sir. No, we're talking about, we kind of got flipped here. Opponents of the bill first. Step on up, Mr. Hicks.
Mr. Chairman, I'm Chip Dix on behalf of the clerks, and I don't think I'm opposed to this particular bill, because what it does is it, and I'm only speaking with respect to the clerk's committee. The rest of the aspect of the bill is a policy decision, which this committee is well capable of making. So, with respect to the clerk's fee, I understand the clerk's fee is being eliminated from this bill. We had some concerns about the way the bill was introduced, discretionary, and put the clerk at odds with their local governments. So the suggestion I made on the House bill was either make the policy decision, have the $10 fee because clerks provide valuable services on a user fee basis to do that, or eliminate the fee, and otherwise it'll have a fiscal impact. So I don't think I'm in opposition to the bill because it eliminates the fee. As I understand it, I haven't seen the substitute.
Mr. Chairman, so, Chip, so you're saying that the clerks are okay with doing this additional work and not receiving a fee from it?
Mr. Chairman, I'd say to Senator McDougal, that was not our preferred position. Our second position is that if you are going to eliminate the fee or make it discretionary, which this body did last year and the House Courts Committee did last year, if you feel like the fee ought to be discretionary, then we would ask you to delete the fee altogether. If you feel like that the fee is valid, then our preferred position is to have the fee. So we're sort of a little bit on the fence there.
That's about right.
Mr. Chairman,
Yellow right there.
Mr. Chairman, so before you totally run away, so if you eliminated the fee to y'all, but didn't raise the fee on anybody else, you'd be okay with that?
Mr. Chairman, I would say to Senator McDougal, if you eliminate the clerk's fee, then obviously that is going to reduce the revenue in the clerk's office, which is why the bill goes to finance, I think. And so, but that's a policy decision. Somehow or other, the clerks need to get paid for this work, whether it's on a broader basis or whether it's direct to the clerk's fee.
All right, supporters.
Mr. Chairman, did, Mr. Hicks, do you think that you make up that revenue on a $20 fee assessed on criminal charges and tickets?
Mr. Chairman, I would say to Senator Dees that money, the $20 money is dedicated money. It does not come back to the clerk's office.
Mr. Chair, that money goes to pay the retirement of Mr. Jones' employers.
That's correct.
All right, supporters.
Chairman, I'm John Jones with the sheriff. This is an appeal, and we very much support it. It's a little bit similar to the bill that you passed last year that didn't get from the other side in terms of the courthouse and courtroom security fee. It went from $10 to $20, and that is certainly a part of this bill. What the bill does is tries to balance fees, and if you have an increase in a fee, we felt like a decrease in another fee would be appropriate. So that's what this bill does, it eliminates the concealed carry to the extent we can. We can't go below $5 because that's what the state police have to pay the FBI to run the check. So it's a net increase of revenue for the locality, and it's optional. The locality has to have pass an ordinance to increase the fee by that much. Will have to be used for courthouse and courtroom security services in the sheriff's office.
Mr. Chairman, members of the committee, I'm Corey Stewart, and this time I am here on behalf and in my capacity as chair for the Board of Supervisors of Prince Edward County. On February 23rd of last year, Prince William County became the first county to eliminate, to the extent possible, the concealed carry permit fee in Prince William County. Unfortunately, because of the state's mandate, $15 of that fee remains, and we want to thank all of you for considering this legislation, and especially Senator Chase for putting it forward. Of course, there was an impact to our sheriff's office, somewhere to the tune of, we didn't know at the time, we knew it was somewhere between $130,000 and $195,000 per year. So we worked with the sheriff's department to make them whole and replace the fee loss with the direct hire of a couple of sheriff's deputies that were otherwise financed through the fee. The impact in Prince William County is good. We wanted our citizens, we want to place no unnecessary impacts or restraints on their ability to carry a firearm concealed. We think that it makes all of us safer. And as a result of that, at least partially as a result of that, the number of permits that were processed and approved last year went from 4,000 the year before to 6,500 in 2016. So I can say from Prince William County's experience, it's doable. You can work with the clerk's office and with the sheriff's department to make sure that the impacts are negated. And we look forward to being able to completely eliminate the fee in its totality at some point. This is a step in the right direction.
So, Mr. Stewart, so am I understanding you correct that your focus is on eliminating the fee? So if we took the $10 and used it for something else, a state priority, like instead of returning it to a local option, you'd be okay with that too? So if we left the beginning part of the bill, $5 to state police, and we did not raise the $10 local option, would you be okay with that?
Well, I'm not quite sure of your question. We would like to have the option of removing the entire $15 is now look, if you take away the $10 and you place it to some other state function, that's fine with us. We just want the ability to eliminate the fee for our citizens completely. That address it?
All right, great, thank you. Next. We'll ask the same question, Mr. Jones. Yes, sir.
Well, Van Cleave, President of BCDL, we support the bill. Concealed carry permit really isn't like any other permit. It's fairly unique because it deals with the right to keep and bear arms, something we probably shouldn't even need to have a permit to do, since the Constitution doesn't mention open concealed. But it's like a public safety thing. We like this bill.
Yes, sir. Thank you. Yes, sir.
Mr. Chairman, ladies and gentlemen, Rob South of South Richmond. To address Senator Douglas' concern, the language does say that you may charge, not in excess. So the clerk would be free to charge the standing 10 for minor things like stickers and $20 for real permit. Absolutely, we don't have bureaucracies are. Permits are mandated and put upon law-abiding citizens as a matter of public safety. I think we can all agree that in a perfect world, public safety and judicial system, the cost would be borne by those that render the system necessary, criminal offenders. That's what this bill is about. Thank you.
Thank you very much.
Mr.
All right, Senator
I
Douglas.
just want to make the point, that is not accurate. The clerks don't have the discretion, it's the local government. And the local government would have the discretion to impose that on traffic cases, not particular types of traffic cases. So it's either they impose it or they don't impose it, is the issue. And so, Mr. Chairman, I would tell I voted, much to Mr. Jones' chagrin and some of my local sheriffs, I voted against the raising of the $10 fee last year. If that's in the bill, I'm going to be a negative vote.
All right, Bill's before us.
Mr. Chair,
Senator Peterson.
I respect Senator Chase, and actually I support concealed carry rights, but I don't like this bill, and I'll be honest, and I think Lori Haas said it very eloquently, and that is, everyone has to apply for a license. You gotta apply for a driver's license, an attorney license, a marriage license, and we all pay a fee associated with that. I mean, you have a right to the jury trial, and you gotta pay a filing fee when you file a lawsuit. So I don't like this idea that we're gonna take one constitutional right and make it somehow exempt from license fees, and everybody else has to pay a license fee. And, so for that reason, with all my affection for Senator Chase, I'm gonna move the TBI bill.
Second. It's been moved and seconded, pass the bill by indefinitely. Before we vote, discussion, Senator Key.
Yes, Mr. Chairman, I perfectly agree with eliminating the fee for concealed handgun and leaving it to the clerk so that it's not mandatory. My concern is, I don't think it's appropriate to make somebody who's speeding cover the cost of the concealed handgun permit. And that causes me great concern. I understand that the handgun and no cost for that, but I don't see how we can switch it to somebody who's speeding. That's my concern with the next.
Mr. Chairman?
Mr. Chair. Point of order, does this bill, comply with the single purpose, clause of the state constitution?
Do you really want to raise that here? All right, I thought I heard something from my right. The motion is to pass the bill by indefinitely. All in favor, signify by saying aye. Aye. All opposed? No. Motion goes. Very, very creative. Never cease to be impressed by Senator Chase and Mr. Jones. All right, thank you. Your second bill?
Yes, thank you, Mr. Chairman. Senate Bill 791, you heard last year, and I'm very grateful to each of you for actually passing this bill. It actually went from this committee to Senate Finance, came out without a fiscal impact statement, and made it all the way over to the House, where it was gently laid on the table and appropriations on the House. This is a very simple bill. It makes the $10 fee that the clerk of court is now required to charge for processing a concealed handgun permit application or issuing a concealed handgun permit discretionary with the clerk. So it's optional. It makes that $10 fee optional. Counties may choose whether or not this is a good option for their county. And, you know, me personally, I feel like we should not be charging folks a fee to exercise their Second Amendment rights. I mean, that's what it comes down to. And so,
Congratulate you on getting through last year without a fiscal impact statement. You were not similarly successful this year. It has one. So, if it is reported, it will need to go to the Committee on Finance. Anybody have any questions or hatred about the bill? Hearing none, anybody who wishes to speak in favor of this bill, step up. Anybody who wishes to speak in opposition?
and I would like to say that NRA and the VCDL support this bill. So I think Karen was her led speech.
Sorry, it took me longer to get your name. Aaron Woodward, National Rifle Association, we definitely support this bill. It is permissive to the clerk to opt in and just change this one word to may, so.
Thank you. Yes, sir.
Phil Van Cleave, VCDL, just confirming what Senator said, we do support this one.
Thank you very much. Yes, sir.
Just to reiterate, concealed handgun permit does address the constitutional right, and it's not a request. There's nothing being performed on behalf of the applicant. It's being performed on behalf of the rest of the state, the rest of the citizenry, to decide to put these rules and these hurdles before the applicant. So it's perfectly right, it makes perfect sense for them to bear the cost out of the general tax fund rather than the individual applicant. As far as calculating the cost and the loss, it'd be interesting to go back and look to see how much money was lost when they stopped charging fees at the voting booth.
Anybody else wish to speak in favor of the bill? Yes, ma'am.
Tracy Gordon, Bruce William
Chairman, Andrew Goddard, Virginia Center for Public Safety. As I said in previous bills, somebody's here conflating getting a concealed carry permit with the constitutional right to keep and bear arms. The concealed carry permit is not a barrier to carrying, to having a constitutional right. It's only something which the public is going to give you as permission to do in their presence. And therefore it's not a bar to your constitutional rights.
Yes, sir.
If this is what happened to clerks, and I'm not balancing on this particular bill, like the last bill.
No, this was the clerk's bill.
You thought this was the clerk's bill? Well, you know, Senator Chase and I are buddies, but this is not a clerk's bill. So the clerk's perspective on this is that they're doing work to provide services, and this is a fee for services. The clerk's fee goes into up to a point to pay for the operation of the clerk's office, and then after that it goes into excess fees. And that's why this will impact. And excess fees are split 2/3 for the Commonwealth and 1/3 back to the locality. So the clerk is put in the position, if this bill passes, of saying to the locality, particularly in those excess fee localities, all urban suburban localities are in excess fees, we're going to reduce the fees when the locality funds part of the clerk's office. And that's an untenable position for the clerk. So the position on this bill is, if you feel like the fee ought to be eliminated, just eliminate the fee, and then deal with it otherwise from a fiscal perspective. If you feel like the clerks provide valuable services for that fee, and this is a fee for service, then we'd ask you to gently lay the bill on the table.
Mr. Chairman. The clerks are constitutionally delineated officers of government, correct?
That is correct, sir.
Mr. Chairman. Clerks are elected for the longest period of time of any officer in government, constitutionally delineated or not, 8 years, are they not?
Mr. Chairman, I'd say there's an individual that is correct.
Mr. Chairman. Mr. Chairman, I asked Mr. Dix, why is a constitutional officer who is elected for the longest period of time not able to make the determination about whether they can charge a fee or not if it's for service that they're providing? It seems quite disingenuous to me to say, I want to be elected, I want to serve the people in a constitutional capacity, but I don't want to make this decision. You, who are elected in a different constitutional capacity, make the decision for me. We certainly, the majority of us voted for the bill that would eliminate the whole permanent structure as it is, that's moving on through the process. This is one that I think that y'all should have, the clerk should have the equal opportunity to make decisions if we do, and I'm going to actually give you that opportunity.
Mr. Chairman, I don't think that was a question, so I will not attempt to answer that question.
Don't you agree?
I think I'll have to take it under consideration. Thank you.
All right, Senator Howell.
Thank you, Mr. Chairman.
Do you have a question or
I have actually a question.
Okay.
I believe you were here when we first instituted this fee and approved the concealed weapons permit. My recollection, and I'm wondering if it's the same as yours, was that the NRA approved this fee and it was part of the deal at the time of putting forward the permit.
We're going back to the 1950s.
Mr. Chairman, I would say to Senator Howell that I would defer to Senator Sasslaw since he's been here since Thomas Jefferson. But I honestly don't recall the specifics of that negotiation.
All right. Any other questions? Hearing none, bills before us. Motion to report and refer. Is there a second? Second. Properly seconded. All in favor, signify by saying aye.
Aye.
All opposed? No. Vote against, please. Congratulations. All right, next we have Senator Servell. I thought we were left out.
You don't have a roller case?
We got a handful. 1439.
That's legal work, by the way, it's not.
All right, Senator Sardell, this is a bill, nearly identical version of this bill was introduced in 2016 by Senator McEachin, and that bill did not emerge from this committee. So if you would refresh our recollections so we can talk about this bill.
Yeah, this bill has a little bit of changes to it because of some of the legal changes that happened last session. So basically what this legislation says is you can't transfer a firearm without going through a licensed firearms dealer. There's several exceptions for that. Case between failing transfers required by law, transfers pursuant to gun trusts when people die, imminent harm or death, if you're in the presence of the owner and it's not in the firearms show, subject to a proper background check. It basically ensures that we have a background check for every type of gun sale that occurs. Public supports this. Polling that's been shown, I have a McClatchy poll, nationwide poll, July 5 through 9, 2016, showed that 90% of Republicans
So in
support
other
this.
words, you closed the loopholes that Senator McEachin left in his bill last year.
Maybe one way to look at it, Mr. Chairman, I would just say that this contemplates the background checks that occurs at gun shows now, and it says you can use one of those to satisfy this bill. So if you make a transfer and you have a check done by state police at a gun show, you're in a safe harbor.
The state police officer that attends the gun shows.
Right.
Where are they going to be for other sales? Go to the state police headquarters?
For other sales, no, for other sales, this bill says you have to make a sale through a licensed firearms dealer.
Any questions to the patron?
I want to understand that. So I've got a gun, just doesn't give me the ability to sell it, and it just takes it away.
Takes it away unless you sell it through a licensed firearm dealer.
Further questions? Senator Peterson.
And this may have already been addressed, but if you receive a gun as a gift, like that's exempted, like say your father buys you a gun, or you get it through an estate or something like that, is that exempted?
Section 20 says if it's a transverse bona fide gift made by or to a member of a person's immediate family is defined in 6.2/1300, and the gun passing down on death is covered by on lines 23 through 24.
And I would point out that that is a direct line of parents, grandparents, child, siblings, and spouses. But if your uncle were to give it to you, that is a violation of the law unless it is for a licensed firearm dealer.
Correct.
Let me, further question here. I mention this because back in my youth, when John Reagan was run back to the Washington Redskins, he at the end of the season gave a shotgun to all the members of his offensive line. And obviously he would have purchased those through a firearms dealer by virtue of him giving it as a gift to say Joe Jacoby, Russ Graham, Jeff Bostic, et cetera, et cetera. Would that then violate the statute?
I think it would, as long as none of them were direct family.
All right, any further questions? Anybody wish to speak in favor of this bill?
Good afternoon, Lori House of the Educational Fund to Stop Gun Violence. We strongly support the bill. This policy is passed in states across the country. It is associated with reduced death of women. It is associated with reduced deaths of law enforcement and also reducing suicides. Background checks do not affect law-abiding citizens. I would speculate that many in this room have been through numerous background checks to purchase firearms. And this is a bill in an attempt to stop prohibited purchasers from the easy access of firearms. Thank you. We support the bill.
Yes, sir.
I would just add to my colleagues that this is a trend that is actually moving across the country. Colorado, Washington, Oregon, and a number of other states have done this in the last couple of years.
Thank you.
Mr. Chairman, Andrew Bellard, Virginia Center for Public Safety. I support the bill as I've done for the last 10 years.
Thank you.
I am Lynn Harris. I'm a constituent of Senator Lavelle, and I appreciate him bringing this bill up for consideration. I support the bill.
Thank you.
Steve Bachman, Fairfax Station. I support the legislation.
All right, thank you. knows your opposition? Just raise your hand. Okay. See the facts. All right, any discussion? Is there a motion? Okay, it's been moved and seconded to pass the bill by unanimously. All in favor, signify by saying aye. Aye. All opposed? No. Opposed, no. All right. Thank you.
Thank you,
Next
Chairman.
bill, Sarah Marker, 1443.
Thank you, Mr. Chair, members of the committee. I have Senate Bill 1443, which deals with
Marker, if you can give me just 1 second. For the benefit of members of the committee and the audience, this bill was introduced in 2016, Senate Bill 411, and passed bill by indefinitely last year by the Court of Justice Committee.
Right.
A different composition. Go ahead.
Yes, thank you very much, Mr. Chair. This bill is also known as related to the Gun Violence Protective Order. Basically, it's to allow removal of guns from individuals who are posing substantial risk of harm to either themselves or others in limited circumstances. There are a small number of states that have adopted such legislation. It's been upheld in courts when challenged in certain situations. What has led to this in most other states where it's been adopted has been a shooting, a killing of someone who, where this provision would have made a difference previously.
Now, let me ask you this question. In the year that's passed, last year we talked about due process challenges, the expert poses. You have any further thoughts about how this is possibly consistent with due process rights of people who can have their firearms seized without hearing?
Right. Mr. Chair, basically, I think that is the most significant issue in terms of this bill. The bill does propose certain things that I think do provide some protections in terms of due process. Whether it meets everybody's standards for what needs to be done, I don't know. I certainly, if there were amendments that someone wanted to offer to try to address this further, I would be happy to do so. What it does.
But traditionally, is it not the way that we traditionally dealt with issues such as this? If somebody is a danger to themselves or others, there's a process for seizing the person.
Yes.
Not his property.
Right. Yes, and in essence, what is proposed here is something that would, when the issue related to, say, a temporary detention order, where you're in effect having the individual who has a mental health issue and does pose a risk to themselves or others, where you in effect put them into an inpatient mental health facility for a period of time, that's up to 72 hours for the temporary detention order. That this is for other situations where the risk is not judged to be significant enough or great enough to be able to detain an individual, but there's still a desire, and frequently it's family members who are bringing this issue to the attention of law enforcement officials and others. So this is an addition, would be in addition to that, not in lieu of that.
Any members of the committee have questions of the agent? Hearing none, those who wish to speak in favor of the bill, please step up.
Josh Rhodes, Education Fund, Stop Gun Violence, support this bill. It'll take just a little bit more time than I usually do with the bills. This is a new type of order, a gun violence protective order. It is based, it's very similar, for instance, to many states that do on a DV temporary order, that they will remove the firearm in an ex parte hearing, and then come back for a full due process hearing 14 days later. This tracks to what many other states do. There has been constitutional challenges to this type of order in Connecticut. Those have survived. There's the temporary removal of the firearm on an ex parte DV order has withstood constitutional scrutiny. So both on the due process grounds and the Second Amendment grounds, the temporary order here has survived. I just want to give a couple of benefits to this bill. It gives law enforcement clear legal authority to remove a firearm. They have to go to court and get a court order. And they can remove a firearm for 14 days. They come back for a full hearing to determine on clear and convincing evidence whether someone poses a substantial risk of injury. There's some new data out of Connecticut that is very, very compelling. It's found that the people who are subject to these orders have about 40 times higher suicide risk than the general population. For every 10 to 20 orders issued, one life is saved. I had the honor to talk to some law enforcement who use this process, especially CIT officers, crisis prevention officers, and they say this is one of the most important tools that they have now to remove a firearm, to save someone's lives, often to get somebody into treatment. And the states that are using this have reported back very favorable results. It's a temporary removal. In this case, only law enforcement could ask for it. It's subject to 180 days, and the evidence is very clear that this is saving lives. And the law enforcement officers that I've talked to and have written about this are very encouraged that this is a way to help stem part of the suicide crisis we're facing, and also to reduce the incidence of intentional shooting.
Thank you very much. Yes, ma'am.
Hello, my name is Lisette Johnson. I am a survivor of domestic violence, gun violence, shot 3 times by my husband, who with the same gun at the same time took his own life. This particular measure could have made all the difference in my children's lives and my life, and my husband might still be alive. What had happened, you know, we know that I'm also a domestic violence victim advocate, and we know that control and coercion are much greater predictors of lethal violence for women in domestic violence situations than physical abuse. That evidence is out there. In this situation, my husband was very controlling. He was verbally abusive. I had nothing to go to the police with on a protective order. Nothing. This could have allowed me to at least get the firearms out of the home while we were trying to negotiate a divorce. His family would have been in favor of it. He had threatened me before, so I had some evidence that he was deteriorating emotionally, and I'm very much in favor of this.
Thank you, ma'am. Yes, ma'am.
Ms. Hoffman from Fairfax Station, I support the legislation and a constituent, and I'd like to thank Senator Gardner for bringing it forward.
Thank you.
Good afternoon, Lori House of Educational Fund to Stop Gun Violence. We support the bill. I just want to offer some remarks with regard to the temporary nature of this. This follows the judicial process of a protective order. Protective orders are issued for a particular amount of time. This is the same sort of vehicle. This is issued for a particular duration. Right now, the bill includes 180 days. However, during that 180 days, the respondent could, after seeking treatment and after being past the point of crisis, could petition to get their firearms rights back, get their firearms back during that 180-day period. The duration of the order, the respondent can petition during that. We have seen evidence throughout the country that when a person in crisis is separated from his or her firearm temporarily, that person's lives can be changed, they can get the help they need, they can get the services they need, and they can come out on the other side a lot more whole. During times of crisis, with people having access to lethal weapons, we lose too many of those people. Suicide is on the rise in the state of Virginia, and we are trying to attempt to save lives with this measure. And again, it follows the judicial process of a protective order. And we use those in Virginia to protect women.
Sorry, time's up. Thank you very much. I'm sorry. Yes, sir. In opposition to the bill.
Philip Van Cleve, Virginia Citizens Defense League. Yes, we oppose the bill on lack of due process. I mean, you just can't take away somebody's constitutional right on a whim. It's every other time this comes up, you go through due process. Also, please don't model our state after Connecticut or California. Thank you.
Historians all know, yes, the Supreme Court. We do not take a position on this bill, but just wanted to raise a possible implementation issue. I apologize to patients for not being able to address it in advance. With respect to the requirement that the court conduct a hearing to determine if a third party is not prohibited from possessing a firearm, that may create some issues with what sort of evidence the court would have as to whether that person is not prohibited.
Thank you. Appreciate that. All right, Bill Forrest.
Move to report.
Second. The move and second will be reported. All in favor, signify by saying aye.
Aye.
All opposed? No. That carries. There's the report. Thank you, Senator.
Thank you very much.
All right. Senator Steph. Senate Bill 831.
Chairman, Madam Chairman,
Speak loud.
please.
Oh, nobody speaks Latin.
Okay, so, I'm sorry, Mr. Chairman, we're gonna take up Senate Bill 832 first.
Yes, we are.
Okay.
Can you make your presentation in Latin?
It's a very, very difficult bill. I'm not very fluent in 16th century Latin, either are a bunch of my constituents. So what I was hoping to do was try to clarify this section of the law and change mutandis to, with the necessary changes having been made. I believe that's more clearly understood by a majority of the population in the state of Virginia.
Senator, a couple of things that I would point out to members of the committee. First of all, some of our, a member of our work group looked through the code, and this term is found at least 156 times throughout the code. And I suppose there is a concern, and those of us who are lawyers litigating issues in court know that we're asked by judges if it says if we change the law, why did you change it? And why did you change it in one place as opposed to 155 other places? They must have meant something by it. And so the question that was raised is if it's appropriate to change this here, should we change it everywhere? And I know that ain't your bill, but if we are going to look at doing that, maybe a proper place for that to be examined is by the Code Commission.
Mr. Chairman, if I may, I agree with you 110%. This was brought to me by one of our constituents who had no idea what it meant. And with that, next year I'd be happy to bring 156 bills back and change it 156 times. Absolutely happy to do so.
It's actually what the Code Commission is for, and they'll do it at one time.
Mr. President, Mr. Chairman, with that, we need to have a motion to pass per item, this piece of legislation. The Code Commission.
Is there a second to such a motion?
Second.
Mr. Chairman, this motion is sent to the Code Commission. As Chairman of the Code Commission, I would strongly object to that. Everybody knows what how do you pronounce it? The Latin names. All lawyers do, not that we can pronounce it. And that's it.
Mr. Chairman, if I may, with our Second Amendment responsible individuals who actually sit down and read the code, this was a very big concern from a bunch of them. So that's one of the reasons why I specifically addressed it in this section of the code. Just to truly clarify it so we understand those things.
Senator Howell?
As the second young lawyer to be appointed to this committee, and someone who feels it's sort of my role to try and make the code understandable to lay people, I think he's onto something. And I'm wondering if the Code Commission could actually look throughout and maybe put brackets with a definition after it.
I think that, I don't think any of us object or disagree with you. But there's a motion properly seconded, pass the bill by, ad infinitum, with a letter to the Code Commission asking them to examine the replacement of the Latin term everywhere, 156 plus locations. All in favor, signify by saying aye. All opposed?
No.
Next
Mr.
bill.
Chairman, next we have a little bit more complicated, it's Senate Bill 831. I'm not a lawyer, I'm not an expert at this, but what this tries to do is clarify the code with manufacturing in inference for personal use and profit amongst that. And this was brought to me after I sat down at one of my judges' meetings, and we went back with the inconsistency in the code, whether it was being grown or manufactured for profit, or if it was grown or manufactured for, I guess, given to those who need marijuana from a medical perspective. So what we tried to do here was to correct that and clarify it in the code so there's no further questions.
I'm sorry, did I interrupt you?
Yes, sir.
All right.
We're good.
Any questions from the patron? We spent a little bit of time looking at this in the work group that we convene a couple of times a week to go through this. And this is a group with defense lawyers, prosecutors, and a broad spectrum. And it's not one-sided at all. And Mr. Benjamin, would you mind walking us through some of the concerns that are identified?
Currently, we have graduated punishments for possession of marijuana with intent to distribute. Punishment increases with the weight of the marijuana possessed with that intent. And so the group gave some thought to whether weight could also be used for manufacturing crimes. But the problem there is that we couldn't determine what it was actually you would be weighing. So that did not appear to be a solution. There is a disconnect because if a person grows just one plant with the intent to distribute, then they're facing 5 to 30 years, which is a harsh punishment, some would say, for just one plant. So what do you do? There is an accommodation defense for possession of marijuana with intent to distribute. It would make sense that there would be a similar accommodation defense for growing marijuana with intent to distribute if you don't intend to profit. One concern that was raised within the group is that it may permit an individual to grow a vast quantity of marijuana and escape appropriate punishment if he's able to persuade a fact finder that the field of marijuana was being grown just to accommodate some people. I'm not sure. I would trust the fact finder to be able to discern the difference between a field of marijuana and somebody's claim that that was an accommodation. But that was one of the concerns that the group noted.
Mr. Chairman,
Senator Edwards.
and this is a question probably to council as well. It's my understanding that the accommodation defense only applies if you plead guilty, and that as the judge reduces it to a misdemeanor, because the transfer was an accommodation only. Am I right about that, or am I wrong? And what I was thinking is, what this bill does is allow it to be presented before a judge or jury on the finding of plead not guilty, and then say, well, if it did, it's only an accommodation. Is that not right, or wrong? Or what?
What the law provides is that if a person is charged with possession with intent to distribute, and they're able to prove that they possessed the marijuana with the intent to distribute only as an accommodation, then they are not guilty of the felony. They're guilty only of a Class 1 misdemeanor.
Mr. Chairman, does that mean you have to basically plead guilty and then ask the judge to say it's only for an accommodation?
No, Mr. Chairman, Senator Edwards, it does not require you to plead guilty. You can plead not guilty, and in the course of it is an affirmative defense. You have to prove that you did not intend to profit, that you only had as accommodation.
Well then, Mr. Chairman, what's the difference between that existing law and this bill here?
This bill extends the accommodation defense also to the crime of manufacturing marijuana. Currently, there's an accommodation defense only to the crime of possession of marijuana with intent to distribute. There is not an accommodation defense to the crime of growing marijuana with intent to distribute.
Mr. Chairman. We've all been here for a number of hours, and I think that the concept that he's trying to address is one that there's some logic to. What I think he's trying to say is somebody that has one plant of marijuana in their basement under a grow light, they would be guilty of manufacturing marijuana and could be subject to a 5-year penalty. And if they're doing that for themselves or for themselves and their friends, maybe the 5-year penalty as a mandatory minimum is a little excessive. I think that that's what we're trying to articulate. The challenge is, how do we parse out that one plant in somebody's basement with a grow light for themselves and their friends versus the rest of it? And Mr. Chairman, I don't know that I have the words to articulate this. So maybe the better way might be to use more of those Latin terms that the understanding came up with, and then let Mr. Sonny DeStefano work on this between now and Monday. If he comes up with a way to parse that challenge, then we could bring it back. But I don't get the sense that it's an easy challenge to parse.
Mr. Chairman, if I may, the backstory on this is there was an individual who was manufacturing it for his mom with cancer to alleviate the pain of it. And the judge was looking at this and it's not clear for the accommodation defense if it's, what if you are growing a plant to give to your mom? So that's where the confusion was. So what I was trying to do, working with our legislative services, try to address that issue and address it here as if it's grown for an accommodation or manufactured, then it should be a class 1 as well, which really ties to the original intent under paragraph 3.
All right, here's what we're going to do. We're going to pass this by today, and I apologize for doing this late, but we're not going to do this on the fly as people are glazing over. So maybe you can talk to Senator McDougal and the committee council, and we can work on it.
Mr. Chairman, I'll offer that if we can't come up with a solution that we can bring in our conversation. And I think the issue is pretty apparent. It's just whether we can make the words equal.
That's fine.
Mr. Doucette seems to have ideas, and maybe we can get some.
All right. So without objection, this will go back to the day.
All right, thank you, sir.
Here's where we are. We've got to get our corrections and impact bills out on Monday. We've got 5 more in the committee, which I'd like to roll through today if possible. We also have 122 bills that were in committee. Right now, we're down to 99 bills remaining in the committee. We do have 1 or 2 that we can deal with quickly on the fly. First, we have Senator Deeds, Senate Bill 1065, which is virtually identical to the bill dealing with reshuffling circuit court judges. Senator Stanley brought last week. Unless Senator Deeds feels a strong compulsion to walk down and here at the podium, we'll take a motion on that bill.
I'll strike the bill.
There's a motion to strike without objection. That bill is stricken. We also have Senate Joint Resolution 241 concerning the appointment of the chairman of the Criminal Sentencing Commission, which is mine, and I'll turn to the sheriff and Senator Stewart to allow me to speak right here. an amendment to Senate Bill 1072.
I think there's a practical information you have to.
You may.
There's a substitute.
Senator Stewart moves, Senator McDougal seconds the adoption of the committee substitute for 1072. All in favor of adopting the substitute, signify by saying aye. Aye. All opposed. The substitute is adopted. This is the out-of-state offenses that would require somebody to go on the
Mr. Boyd raised a couple of issues last week, and there was some legitimacy to it, and what the substitute does over on lines 80 and 81, it basically exempts people who are exempts residences that were established on or before July 1 this year. So those people who are already have established residences don't have to worry about moving. The second issue she raised is one of notice, and we just made the determination that the letter is just too burdensome on the state police. People are assumed to know what the law is. We're all assumed to. Ignorance of the law is no excuse. So I've talked to the state police about maybe doing a better job of providing notice on the website as to what the rules are. So, but the issue of notice is not addressed in this.
So the state police is okay with the principle of residency being inserted into the bill?
Yes, Mr. Chairman.
All right. Now, we're not going to have a rehearing on the bill. Does this address some of the concerns?
So my first concern was heard.
Step up.
I didn't want to
No.
encroach, sorry, Mary Boyd. So my first concern was heard, and I waited for a day and a half to find out about the second concern, including today, and now I'm hearing that it's not being addressed, and I did not raise it to the committee. So if I may, it's not very long. I actually came up with two options, and I have a reason for it. So, being that my second concern wasn't heard by you, and it's not being acknowledged by the VSP, may I point out the problem?
Do it.
Okay.
Go ahead.
Thank you. So without notice, we're setting these people up for failure with an arbitrary felony for simply picking up their children from school. I propose two options to fix this because the rules of the game are changing. Option one is that the state police will notify all affected registered sex offenders of the change in law that prohibits them from loitering within 100-foot certified mail, which is done with our re-registration letters 30 days prior to this becoming law. Option two is a start date of January 1st, 2018 is added with the knowledge that between July 1st of 2017 and January 1st of 2018, these offenders who are affected will register at least once, if not twice, within that 6-month period. And during that time frame, the VSP could get their signature that they have been notified when they re-register in person. If Virginia's trespassing law requires post signs or prior notification for it to be a crime, then shouldn't our loitering laws do the same? Lieutenant Hook said that the number was going to be very minimal. So the cost to send out a few certified letters, we don't know the number, but he said it was very low, is a lot less than arrests, investigations, and incarceration for a crime that had no intent.
Mr. Chair, and I guess Mr. Officer Lieutenant Hook can address some of the issues. And I would point out that somebody that's going to school to pick up their kids isn't loitering.
But that is included.
We're not going to.
Sure.
We're not going to have to debate. State police, you want to step up and respond to Senator Jeanson.
Mr. Chairman, Keenan Cook, State Police. The issue with notification for us is simply that there is not complete parity between sex offender registry and offenders who are prohibited from loitering at schools and daycares and playgrounds. There are several offenses under 370.2 which are not registry offenses, and there are other offenses which are registry offenses that do not prohibit loitering at schools, etc. The biggest category of those being offenders who are offenders against adults. And so if we were to send out letters to the sex offender registry, we would confuse many people into thinking they could not loiter at schools when there would not be that state law prohibition against it. And similarly, we are not in a position to tell for those offenders who are not registry offenders whether they whether they ought to get a letter. They're simply not on our radar screen.
Now, let me just say that if this bill reports out here and reports and re-refers to finance, which means that we've got at least 2 more chances to take a look at this before it leaves the Senate, in finance and on the floor. So if you have ongoing concerns, you can talk to Senator Deeds about it. So, bills before us.
Can I ask a question, please? Let me ask, you know, in my locality, we have a pickup basketball game in an elementary school, and we get 10, 15, 20 guys show up. If one of those is an RSO that shows up and he's on the basketball court playing basketball, and he's waiting for the next game, is he under this statute?
Mr. Chairman, Senator Peterson, he would not be loitering if he is playing or waiting for a basketball game. He is waiting with a purpose, and loitering is waiting without, is lingering without a purpose.
Bills before us. And we refer to the Committee on Finance. All right, all in favor, signify by saying aye. Aye. All opposed. Before this bill is reported and re-referred. Senator Chapin, 1244. We'll do this quickly.
Yes, absolutely.
So, Mr. Chairman, members of the committee, we have a statute that we're seeking to amend, and it's been on the books for some time. It relates to ammunition and relates to restricting ammunition for purposes of public safety and police protection and police safety. This amendment, this bill seeks to modernize that statute by recognizing modern ammunition and that will not penetrate a vest, that will not penetrate a Kevlar vest or safety vest that the officers use. It also makes it clear that the ammunition that is approved for retail sale by the alcohol, tobacco, and firearms people would be legal too. It also makes it clear that you would have to use this ammunition that just possessing this ammunition does not in effect make you guilty of the felony. It would be the use of it in the commission of a crime.
This ammunition may be illegal in Virginia, but legal in Tennessee, West Virginia, and North Carolina.
I think there is ammunition that might be legal right now in other states, but not necessarily legal in Virginia.
So, for people like you, your neighbors, and my neighbors who may hunt in West Virginia, which is 15 miles away from me, or in Tennessee, which isn't far from you, they wouldn't have to leave their ammunition there. They can bring it home as long as they use it. Don't use it in Virginia. Is that right?
I think so. I mean, I think that's one thing that the bill attempts to do, but primarily what the bill is doing is just bringing the code up to date with regard to this ammunition and changes in the ammunition that is covered.
Any questions, Patriot? Hearing none. Anybody wish to speak in favor or register their support for this bill?
Phil Van Cleve, Virginia Citizens Defense League. Yes, we strongly support this bill. I can also answer any technical questions you might have.
Not necessarily opposition. Mr. Chairman, Andrew Garrard, Virginia Centre for Public Safety. I completely support the part of the bill which refers to copper cord bullets. As the father of someone who has a lot of lead bullets in his son, I would much prefer them to be copper than lead for the long-term implications of that. The only thing that concerns me a little bit is if a person goes to a scene of a crime and intends to commit a crime and is carrying this kind of ammunition, the restricted ammunition in their pocket, why should we let them get away with that? Why did they take it there? if they took it there to the place where they're going to commit a crime, they probably intended to use it. I mean, you don't put something in your pocket and take it with you to some place just for the heck of it. They probably wanted to use it, so why do we let them off? These are not the kind of people we should be giving grace to.
Thank you. All right, bills before us. It's been moved. Second. Yes, it needs to go behind it. Second. All right, it's been moved and seconded, the bill be reported and referred to the committee on finance. All in favor, signify by saying aye. Aye. All opposed? Bills reported and referred. Mr. Chairman.
I also have, 889.
Hey, what? I apologize, but we're gonna try and prove you have somebody here for it.
It's pretty simple.
We're trying to cruise through these corrections impact bills.
All it does is add parole and probation to the list.
Let's roll through these. I'm sorry.
I understand.
We've got some folks who have places to go, and we've just got a lot of these bills. Senate Bill 1039, Senator Al.
Thank you, Mr. Chairman. I have an amendment in the nature of a substitute.
All right, Senator Lucas moves, Senator Edwards seconds the adoption of the substitute. All in favor, signify by saying aye. Aye. Opposed, the substitute is adopted.
Thank you, Mr. Chairman. Last year, as I'm sure everybody remembers, we had a really historic agreement on a number of gun bills. One of them dealt with protective orders, and it said persons who were subject to protective orders for family abuse could not possess or transport a gun, a firearm. What this does is expand it slightly in a rational manner to be other permanent protective orders. I'm not talking about emergency protective orders. I'm not talking about preliminary protective orders. These are permanent protective orders that have been imposed by a judge. But what they do is they cover other forms of protective orders rather than just family abuse protective orders. So, for example, it could be a workplace protective order. This fills in a gap between the state and the federal laws, and I hope it will be your pleasure to approve this bill.
Senator Howell, thank you very much. Any members of the committee have any questions for Caitlin? Okay. Anybody wish to speak in favor of the bill? Yes.
Mr. Chairman, members of the committee, Ryan Moran, Chair, Secretary of Public Safety and Homeland Security, and having sat through this meeting for, I don't know, 4 hours now, it reminds me just how extraordinary our work was last year. I mean, the bills come before you and they get defeated, they pass, but rarely a party line vote. Last year's bill, we worked together, Democrats, Republicans, for the purpose of addressing domestic violence. And we were able to accomplish that. And I want to just bring you up to date. As soon as that bill passed, we went to work on making sure the implementation of that legislation occurred effectively. We met with a task force of stakeholders, law enforcement advocates, everyone involved, even gun dealers. We had at the table 2 of them to see how we could address the issues that were brought up throughout the hard-fought negotiation. As of now, we've had one of the issues is where do the guns go? And we've had now 66 law enforcement agencies agree to accept the firearms. We've had 28 firearms turned over to law enforcement agencies. As you know, there's no mandatory, and it's not even mentioned in the law. But we've had 66 agencies step up and say we'll accept them, and 18 handguns and 10 long guns have been turned in. So, my point, in 2015, we had 5,600 of these types of protective orders that are in the current law in family abuse. Why I bring that up is because we've done a lot of work on a public awareness campaign. We've spoken to the Commonwealth attorneys, we've spoken to the Sheriff's Association, spoken to the Police Association, we've spoken to campus law enforcement, obviously the advocate community. And so I think we are now prepared to expand this bill, just as Senator Howell suggested we do it last year. But now that we are ready, frankly, there is no reason not to expand it to non-family protective orders. You all, as legislation in 2011, determined that non-family protective orders, you equated those with family abuse. 19.21, 52.10, you equated their seriousness with the protective orders issued in family abuse cases. So it's now time to expand it, and the due diligence has been performed. There's about 2,300 protective orders of this nature. They are final protective orders, as Senator Howell articulated previously, and so I hope you would. Now, there is a second part of the legislation with respect, but in terms of the protective orders themselves, I would hope this community would have to take it.
Thank you. Secretary Senator Stewart.
On the substitute, Senator, I would direct your attention to line 28, subsection C of 19.21, 52.10. So 28 to lines 29. So that captures the non-family abuse permanent or full final protective order.
Also line 24 and line 26.
Correct, yes.
Thank you, Mr. Chairman. Senator Duvall.
For Secretary Moran, just what, Secretary Moran, can you tell me anywhere else that we require somebody to give up their Fifth Amendment rights after they get subject to a civil proceeding? Because in this, you're saying that if you're served with a protective order, you're required to say that you have done or not done something. So if you've done it, then given the government evidence that you've done it, you've not done it, then you're forcing them to say that you committed a criminal offense.
Well, the Senator raises an interesting point. You're addressing subsection C of the bill, lines 33 to 36. There was a great deal of discussion last year when this bill was being negotiated. How do we prove the individual has turned in data? And so this was a method that, frankly, we went around the country to talk to our colleagues in other states to determine what they did. We couldn't find any state that was similar to this, frankly. Some states have registration. It's easy to know if somebody has a firearm if there's a state registration. We obviously don't have that in the Commonwealth of Virginia. But I just suggest to you, Senator, when you fill out a public document, official document, on the bottom of it says, you certify that you have not falsified any of this information. That is indeed true, correct, subject to perjury. So, we're requiring them to sign if in fact they have intentionally included any false information. So I don't think it's a particular stretch to require, and as I recall, if it is a violation of the Constitution, there's usually a gray slip on it, and there's no gray slip on this. Do you still do that, do you?
If I could help.
Before we get to that, I eliminated that. We eliminated the gray stress because we thought they were somewhat.
There used to be a gray fold, not on any of my bills, but.
We went to electronic filing. Electronic filing, you get rid of all the slips.
All right, absolutely. Let me ask counsel whether you have thoughts with respect to Senator Duval's question.
I don't see a Fifth Amendment problem here because you're not required to notify the clerk or anyone that you haven't done something. All that the bill requires is that you certify that you have sold or transferred the firearm. But there's still a something of a technical problem there, because I'm not aware of any place else where we require a citizen, as opposed to somebody who holds an office, to certify certain things. And so we as lawyers might understand what it means to certify something and file it with the clerk, but I'm not certain that a citizen would know that. The problem there could be fixed if the protective order in clear language notifies the citizen that they have 2 business days to sell and transfer, and that they also must file something with the clerk. And so if there's language in the protective order added, then that problem would not exist. Or within the bill, we could take care of that problem by requiring that certification be done on a form prepared by the Executive Secretary of the Virginia Supreme Court. We could also, and then the citizen being served with a protective order has a form from the Supreme Court that they could use to certify, that could tell them that they must file it with the clerk.
So let me ask you, let me follow up. So we're creating a misdemeanor for failing to file paperwork.
Yes.
Okay. And then moreover, should somebody fail to file paperwork, even if it's inadvertent, even if they've divested themselves of the firearm, SWAT team can come, and investigators can come through the house and conduct a search.
Yes.
For other things.
Yes. And so that's why I would advise making it very clear that they have this requirement and making it easy for them to fulfill it. And we can draft language that does just that, that accomplishes the idea by giving fair warning to the person of what their obligation is.
Senator Stewart.
Thank you, Mr. Chairman. Steve, correct me if I'm wrong, but when these executive orders are issued, typically you have a form exactly what you're saying, that typically a sentence on there that says you may not possess a firearm.
There probably is, there must be. But, and so if you included something that says, in addition there, you must.
Prepare with, when the judge signs the order, the protective order, so aren't they already under the contempt power of the court? They don't abide by that order. The judge has the ability to fine them in the contempt court, so they can fine them or imprison them. There's a federal statute that is a 3-year minimum mandatory sentence if you're in possession of a firearm. If you're under a protective order. I understand what you're doing. Are we just really piling on unnecessarily? Just piling on charges. I was a prosecutor one time, and I hated to pile on charges unnecessarily. It just seems like we're piling on.
My main goal, Mr. Chairman, is really the expansion of the coverage for people who are subject to permanent protective orders. I think that's the significant part of the bill. If you all would like, and I should make the motion, that we take out the part dealing with certification, I'm fine with that.
Mr. Chair. I would move that we strike lines 33 through 36, which is the notice provision, and just keep the rest of the bill as is.
I'll second that.
Mr. Chairman. Mr. Chairman, I heard a lot the other Wednesday about the use of vetoes and those being upheld. We also have a commitment that if the governor decided to amend this and return this to us with this or any other type of provision, that you would help us to reject that.
I absolutely would.
All right, motion to amend is before us. All in favor of the amendment, striking lines 33 to 36, signify by saying aye. All opposed. That amendment is made. Bill before us, speakers in support. Yes, sir.
Chairman Michael Sack-Collins, for the City of Westbrook, on behalf of the Virginia Association of Common Attorneys, and we are in favor of the amendment in the nature of the substitute. One technical, and for all the reasons that are already said, there would be one technical amendment I would suggest, and that's on line 28, of the amendment in the nature of the substitute, and that makes reference to a subsection C that you just struck. And so you all also need to strike the language on lines 28 and 29 that added the language as far as subsection C. But again, we are very much in favor of this, adding these particular protective orders where a court has made a final judgment that there's a substantial likelihood of an act of violence, force, or threats.
Subsection C is another statute. This is a statute. It's fine.
I would throw that.
All right. Thank you. Anybody else wishes to speak in favor of this? No, we're out.
Support the bill and just note that prior acts of violence would best predict of future acts of violence.
Thank you.
This is Sheila Varkey on behalf of Virginia Poverty Law Center, and we support the bill. Thank you.
That's the effect orders for acquaintances, I think is what it was termed at the time, non-family members. But is it preliminary emergency, just final? And we don't have to take it.
Protective order, protect the health and safety of the petitioner and family or household members upon the issuance of a petition or warrant for any criminal offense resulting in the commission of an act of violence. This is a permanent protection order. Subsection C is quite long. It goes on about how it shall be served, what happens after service, and so.
All right, Mr. Chairman, I'm not trying necessarily to be negative, I don't want to be trying to do, I'm voting on since we just got the substitute, so maybe we pump this to Monday, but let's give me what those code sections are.
Well, I have some comfort with it because you'll see the existing language on line 28 talks about being served with a protective order in accordance with, in the subsection in the existing statute, says how you serve a protective order, and there is a similar provision in subsection C of this protective order that goes into the minutiae of service.
I'm not sure that satisfies some of the concerns, and this isn't with any malice. It is, as the Secretary pointed out, we've been here for 4 hours, which is fine, but we're about at a point where we're making decisions on the fly without understanding what the impact is.
Fortunately, I guess, it goes to finance, so most of us on that subcommittee are also here, so we could work on it there.
And Mr. Chairman, I would say that we're probably not going to, particularly because this bill is probably not get to this before Monday morning, so we just carry this to Monday morning, we have a chance to look at it. We'll probably deal with it Monday afternoon, but not Monday.
Unless there's an objection.
I'm sorry, I missed part of that, but carry it over till Monday to work on it.